Hello? Okay. So this session is going to be about coming at the problem from a legal point of view, and we're going to tackle and discuss the question of should there be a concept of personal data rights. And Ron Wheeler is somebody who's very near and dear to me. We've worked together, we've known each other, we've been friends for, oh God, since the better part of 13 or 14 years.
Since we were children.
Since we were children. And he was an attorney at Fox for a long time. He's an expert in intellectual property law, antitrust law, and as
privacy law.
Not privacy law, which makes him really well qualified to speak about these issues. Ron will kick off with a presentation, and then the two of us will have a discussion.
Brief, absolutely. Thank you, Talal. So I'm just going to do a few slides. I'm not an expert on privacy law, as mentioned. I am pinch hitting in this particular slot for someone who really and truly is. I want to do a little shout out to her. Her name is Nadezhda Portova, and she's a professor at Tilburg University in the Netherlands. And she's written this book, which for anyone that is interested in this topic is the dernier cri, I believe is the French term, Property Rights and Personal Data, a European Perspective, but it's basically a worldwide survey of the subject, and I highly recommend it. It's ridiculously expensive, like many academic publications, but it's I think it's worth the money. Anyway, I'm going to try to do my best to summarize her views and as well as a few of my own here. So deliberately a question mark, property rights and personal data, question mark because of the fact that they really don't exist today, but they could, and that's my theory. Okay, so this is obviously a map of the United States, but the key point on this slide is the origin of the propertization idea is the U.S., and it's a function of the federal structure of the U.S. and the nature of U.S. legal system, common law legal system, and how it deals with privacy. 50 U.S. states, if you want to have expanded privacy rights or property rights, in this case, any kind of change to the privacy treatment of personal data, you have to have 50 action plans. So it's basically a function of the structure of the United States legal system. So it's also, just to go into a little more detail, in the U.S., the traditional conceptualization of privacy is mere secrecy of personal information, especially of an embarrassing nature. So the remedies are limited to state law tort claims, so private rights of action against individual data collectors for invasion of privacy or something revealing of embarrassing nature. No, I'm sorry for the legalistic term, erga omnes, but it's actually a very important concept. To the benefit of having a property right, just as it is for copyright holders and for patent holders, is that it runs against the entire world, not just to parties with whom you're in privity or the first person to whom you disclose something in the case of privacy data. So it's a very important improvement over the contract law-based system that currently obtains, at least in the United States. Another aspect of the U.S. law that's relevant here is our constitutional concerns and limitations. The First Amendment provides a very broad scope for data collectors, people gathering information about each of us, to collect facts about data subjects. So it's a very expansive subject, basically a right to gather, to collect data. Data, on the other hand, under the Constitution, data subjects have Fourth Amendment rights against unreasonable searches and seizures and due process rights to not be deprived of life, liberty, except pursuant to due process. But those rights apply only to government action, which is a relatively small piece of the problem, and private actors are largely unaffected. And another factor, which is not unique to the U.S., but is particularly relevant to what Matt was talking about the 50-mile radius, the political strength of the U.S. information and data collection and direct marketing industries, now augmented by the burgeoning machine learning and AI industry, which wants to analyze all the personal data, is a very high obstacle to effective legislation in the U.S., makes effective regulation difficult, if not impossible, everywhere. Going back to the map, even where it is possible, in my home state of California, which recently enacted a fairly tough, not quite GDPR, but fairly tough privacy law. You have to repeat that same battle times 50. A lot of people think that our FTC could overcome these political obstacles, but it's far more likely that they would adopt the lowest common denominator out of the 50 states. So, and last but not least, even with regard to the FTC, there's a much greater distrust of regulatory solutions than elsewhere, for example, and here in Europe, home of the GDPR. Okay, so let's discuss the arguments for propertization of privacy. First and foremost, it's been mentioned several times this morning, it's consonant with what natural rights theory, John Locke and many others going way back to the ancient Greeks, of individuals to dominion over information about themselves. In the US law, there are some distantly related examples that already exist. For example, life story, I put rights in quotation marks because it's not an officially recognized right, but the routine for any film or television show that's based on someone's actual life for the producers to attempt to acquire life story rights. And that's essentially personal data with regard to someone's life story. It doesn't have any official legal status, but it works to finance the movies or TV shows, so it obviously has some value. Propertization would address, or at least potentially address, information asymmetry between data subjects and data collectors, which is one of the main reasons for all privacy problems worldwide, because the data collectors have far more information about what they plan to do with the data subject's data and than the data subject could ever had. The result is market failure and excess uncompensated sharing and especially hidden redistribution of data subjects' valuable personal data. And Talal mentioned this in his introduction. It's very much akin to theft of patents and copyrights. In other words, something of value taken from, in this case, the data subject without compensation, in part because the data subject doesn't know how much value his personal data has. It addresses the political difficulties associated that I mentioned previously with enacting effective data protection via legislation and regulation by reframing the issue as control over one's own personal data. It becomes an individual thing where it's kind of difficult for a politician to oppose someone having greater control over their own personal data rather than heavy-handed government interference with business practices, which is what a lot of businesses in the US consider the GDPR to be doing. On a practical level, in theory, it gives data subjects a measure of control not otherwise available to them, the right to exclude access to that data, right to monetize the access to the data. It overcomes the constitutional concerns I just referred to in the previous slide because the First Amendment does not permit theft of property. So anything that's defined as property, including copyrights and patents, the First Amendment does not protect the theft of that property. It generates incentives to create a market for technology to manage licenses of personal data, which has been discussed several times this morning, and to protect that personal data from unauthorized access. The analogy here is to development and use of blanket licensing entities for individual songwriters or movie or TV show producers to pool their rights into a blanket license that has great value, and then they receive royalties in return. And then it also, on the other hand, the DRM technology that Talal and I have worked on for many years. That market has worked in the copyright area, which is the idea would be to duplicate that market in the privacy area. And because, as I mentioned, property rights have erga omnes effect, it could and potentially be a harmonization tool used by jurisdictions all around the world, including actually in the EU, even just not GDPR notwithstanding. That's the thesis of Professor Portova. So long as it's consistent, and it would be consistent with local data protection laws. So it's an intriguing way to think about potentially a worldwide solution to data privacy. Okay, but of course there are plenty of detractors of this idea who point out that with respect to the US, there is no clear constitutional basis on which the Congress could enact a new federal property right. The suggestion by Professor Lessig is that maybe perhaps the Commerce Clause, which has traditionally provided an expansive basis for a lot of other laws. Personally, my Commerce Clause jurisprudence is a little bit rusty, but I think it might be a stretch. So it is a challenge. It is inconsistent with the First Amendment rights of data collectors that I mentioned before, but then again, so is copyright. And I think that one is not a strong objection. But the next one is the key one, objection-wise. On a practical level, the same information asymmetries could potentially remain just as they are today, and data subjects would be subject to the same pressure to sell that personal data that's now they own, at least temporarily, just as they click I agree or I accept today. So the right to exclude access that I mentioned would be illusory. The right to monetize access would also be illusory. And because of that, no market for technology to manage licenses of the data or to protect it from unauthorized use would arise. That's the boogeyman of this whole idea of propertization. And it gets worse, actually, because data collectors would now own the property that you've just licensed or sold to them, the data purchased from data subjects, and it would be much more difficult to regulate their use of what is now their property, right? They've acquired it from the data subject. So by individualizing, and then there's one more objection, which is a more of a collective one, that by individualizing the decisions to share personal data, this is actually true today too. It ignores wider society's interest in shared information privacy, a safe space, as someone referred to it earlier today. I think it was Miss O'Shea in Australia, for anonymous and semi-anonymous interactions as a public good for all citizens, regardless of socioeconomic status, the privacy commons that's been referred to. Okay, so where are we? We have pros and cons. So there is a set of authors who proposed a solution that accommodates both the arguments for and against. It's essentially a hybrid propertization proposal. Paul Schwartz is the main proponent of it. He wrote an excellent article, which is happy to provide a citation for anyone who wants it. First of all, we want to make sure that certain fields would be exempt from propertization. Government data collectors and First Amendment press. There would be no property and personal data vis-a-vis law enforcement. Police would not have to bid for your personal data to investigate or prosecute you. No reference to eminent domain or takings. That was a reference to in Talal's, I think it was, to eminent domain. Perhaps that should be regulated, but it would not be pursuant to this propertization proposal. I think he wouldn't object to that. And then there'd be no claims against press for using personal data in news stories, for example. But the key proposal Professor Schwartz makes is that for private data collectors, there would be limitations on what the data subject could give away. So this is to address the whole illusoriness problem. There would be, the data subject would be not permitted to sell, fee simple, if you will, to his or her data. The only thing that would be permitted would be licenses, and licenses would not be permitted to have the right of sublicense. So and the sublicenses, the further transmissions, which are now completely opaque to the data subject, would be subject to a further negotiation with the data subject. And this would be by law. So in other words, it would not be possible for contract to contract around. That's not completely unheard of even it's very common actually in European law. But there are also federal copyright law provisions, for example, permitting termination of transfers after a certain number of years, regardless of any contract to the contrary, so that it's not foreign to US law either. Professor Schwartz also proposes that there would be an inalienable right of exit from previously agreed licenses. And the analogy here is to state lemon laws for used cars that turn out to be unrepairable, and for which the seller had not disclosed the condition. And then the same above mentioned federal copyright law, which allows termination of previous transfers. And then another element that Professor Schwartz proposes is statutory liquidated damages for violations set by the government just as they are for copyright at a very high level, as you may know. It could be much lower in this case, but it would obviate the need for any individual claimant to approve damages, which are a huge deterrent under the current scheme of tort law. Copyright law has statutory damages. The Video Privacy Protection Act, even in the privacy area, has statutory damages, and there are many other examples. Private rights of actions would be allowed, as well as public ones, to avoid the problem of insufficient government resources, particularly in our system of a hugely politicized and deficit-laden federal government. Individual actors and of course lawyers that represent them, class action and so forth, could bring cases. And then the last proposal is perhaps the most pie in the sky, which is one or more new federal institutions to regulate the information provided to data subjects and to enforce the rules. So he proposes specifically something called the U.S. Data Protection Commission. Turns out that the U.S. is the only major country on earth that doesn't have one at the moment. So we could fill in the blank, presumably under a new administration, compares to the FTC, who can, at the moment, mandate is limited to deceptive practices only. So non-deceptive ones buried in 17,000 word terms of service are not currently subject to FTC scrutiny. Thank you. That's our introduction, and now we're going to have a little chat about all of this. Basically, I'm not a First Amendment expert either. I've got a long list of things that I'm not an expert in, but from what I've read, it's essentially the right to report facts is actually, there's a whole stream of cases where people have brought defamation cases, for example, against the press, and they have a First Amendment defense to, it's a whole public figure dichotomy and based libel law, U.S. libel law, very generous, obviously, and it's all based on the First Amendment.
It's what paparazzi hide behind, right?
Absolutely, paparazzi. Yeah, it's all First Amendment. I'm in public. My face is available for photography, and there's nothing you can do about it, even if it's a bad picture of you.
There's a case I heard about too with the phone book or someone, right? Someone tried to go after the phone company for printing phone numbers under some sort of copyright
and
violation.
Lost. First Amendment, your phone number is, even if it's unlisted, is it's not something that you're permitted to, you're permitted not to list it, but it's not exempt from if someone discovers it because, a friend of yours has it, and you publish it as a result, then the First Amendment protects your right to publish the phone number.
So with that, I mean, that's actually where, thank you, that's where I wanted to start, which is this phone number case is like a really interesting one, because I think the position that's been taken by data collectors on the internet, these big institutions we've been talking about, is the fact that you're leaving these digital droppings behind on the internet is effectively just a handle to you, the same way a phone number used to be a handle to you. Yep. What's being ignored is the fact that this is obviously something that can deeply profile you versus your phone number. I mean, those of you who worked at the phone company, when it was the phone company, I mean, you told me this, that the best kept confidential information at AT&T that no one was allowed to go near was the usage information of the phone book. Right, it's like who called who and all that kind of stuff. And it's incredible how far we've swung from that, where the data on who was calling who was like the most confidential information at a phone company. At a place like Google is pretty much what's traded on.
Oh, exactly, yeah. That's the first thing they monetize, right?
So you gave it a very American-centric talk, which I mean, between the French and the Americans, I mean, I think a lot of the law in the Western world has sort of been you were talking about Locke and Rousseau and people like that. How much do you think these concepts will travel? I mean, in other places, how much do you think the Western world will actually be a beacon for other legal systems? Because the problem with the internet is you don't quite know where the servers are.
Of course not. Yeah, no, so my 2 cents, I wouldn't, adding to the long list of things I'm not an expert on, my basic recollection of natural right theory is that there actually are versions of it pretty much all over the world. It's actually the European copyright law is much more based on natural rights. The U.S. copyright law is based on utilitarian. It's just like patents. It's to advance the progress of science and the useful arts. So we're actually not a natural rights jurisdiction with respect to copyright and patents, whereas Europe is in both cases. So certainly Europe and the U.S. do not. There's no divide there on natural rights. And even in Asia, which I know a lot less about, I think there is a sufficient basis for people to care about their personal autonomy and their information. I think Toru's comments about Japan bore that out a little bit. And the nice thing about property as a base, you could fit that into every cultural and legislative context, I think. It might play out differently. The rules might be different, for example, to reflect cultural differences. But the same basic concept would be it's a human right, not an American right or a European right. It's a human right for everyone to have a certain amount of autonomy over their personal information.
Well, I guess another observation on that is that we look at GDPR, and GDPR is a very European concept, but the minute that a company operates in Europe and they start having to worry about if they have one shred of data on a European individual because they're liable for how to handle that shred of data across the board.
They are, but on the other hand, the flip side of that is it's only Europe. And so, yes, the negotiations over the safe harbor and transferring data outside of Europe, but the downside of a purely regulatory approach is it really can't be effective in the world of the internet unless it's worldwide. And that's just not going to happen. There will not, I would kind of love to be proven wrong. The likelihood of the GDPR coming to the U.S. is virtually nil.
Right. So do you think I think of GDPR as kind of, I called it reactive earlier in the sense that you lay out some concepts about what companies should do with collected data, and then you correct their behavior when they kind of breach those concepts or those regulations. I think, I wasn't involved in writing it, but I think the way it started was like all this data is being collected, so we can't just go back and force people to stop collecting data the way they put the genie back in the bottle. So let's just regulate what people are doing with it. If you were to go back in a time machine to the beginning and start with the concept of an individual right to data privacy akin to a patent right or a copyright, do you think this thing would have played out differently?
Maybe. I mean, I guess the GDPR, if you think about the structure of European law generally, especially EU at the EU level, it's very congenial to regulatory solutions. So, and actually, Professor Portova makes the point that there's nothing inconsistent. Even if you had started with the property right, and then you would still, according to Professor Schwartz, you still need government to enforce the property rights, because that's the role of a government in any property right system, right? A copyright or a patent is worthless unless you can enforce it against infringers, right? So I think and her proposal is to drop property rights in to a GDPR system and actually strengthen it and actually help with its weaknesses, which have been widely reported. So I don't think it actually matters 100% that it would be dropped in rather than starting from there and added.
So, the other issue is how do you value the breaches and how do you apply remedies? You were talking about statutory, copyright fines and of course, in the patent system, people spend a lot of time working through all sorts of game theoretic solutions to try to value the damages. How do you value? It's not really a data breach here; it's more of a data misuse or.
Right. Well, again, I'm not an expert in statutory damages either, but Professor Schwartz, the VPPA says you can get your actual damages, or provided that you get at least $2,500 in actual in liquidated damages for every violation. And if somebody discloses, obviously it's kind of outdated now, your video rental habits for the last 10 years, and you rented 5,000 movies, a high number, 500 movies in that time, times 2,500, that's actually some real money that people might sue over. And so it's just a matter of legislative process coming up with a reasonable deterrent number and compensatory number. Certainly, like I said, done in a variety of statutes, and that would be his
I saw a hand going up there, but can we get the lady a microphone? But there's that joke I like to tell in these settings about how much is your privacy worth, and the punchline is Facebook's market cap.
Yeah, exactly.
So the question is, how do you give some of that back to the people who are providing the data, I guess? Yeah. What's the question? Then we'll get over to you, Nat, in a second.
Thank you very much for this presentation. Can you hear me?
Yeah,
okay.
There it is.
So I work in the CNIL, the French Data Protection Authority, and we've been asked this question many times, so we are reflecting on it. And I had the two questions on your presentation. Mm-hmm. Well, of course, the important thing that Schwartz, I think, yes. By the way, very interested by the article, is that there is no right, there shouldn't be any possibility for the data subject to renounce or to sell its right to withdraw consent or the right to object. But the question we're asking ourselves is how do you balance that with the necessity to have a balance in the counter-performance and contractual regulation, because we're thinking, what if the data subject agrees to the use of their personal data and touches, I don't know, $5 for it, or I don't know what remuneration, and then the day after decides to withdraw their consent on the use of personal data? We wouldn't want to have a situation where the data subjects would be constantly sued under contract law because there is an imbalance in the counter performances. So that's the first concern we have. And the second one is more an abstract question, but do you necessarily think that there has to be an ownership of data to be recognized for the monetization of data to happen, in a sense that data subjects already give away a license to use their data to data controllers for a specific purpose? This is, I give Facebook the right to use my name so that I can have an account. So this is already a kind of license that is happening. So do you think we have to go to the extent of recognizing an ownership, a property right on the personal data? Because maybe this could be a way of avoiding that the data subject is under pressure of selling their personal data, saying like, look, you don't have a property right on the personal data, but you can grant license to use on data that is concerning you. Yeah.
So I think the only difference is the erga omnes point, which is that about further transfers beyond Facebook. So if you can absolutely, the licenses looks almost identical in both cases in the current system. As you say, you give a license to Facebook to use your data, but what you also give them under the current system is the right to do all kinds of other things with your data that maybe is buried in line 10,000 of the terms of use, which are not subject to negotiation, for example. And the one, under a property model, there would not be a terms of use. There would be essentially my price for my data is $1 or $5 or $10. It's the difference would be that each data subject would set his or her own price for the license of their property, and that their property right would extend beyond the immediate contracting party to which give the initial license, and further transfers by that contracting party would be subject to a separate negotiation. So that's, it's not like a night and day difference. I'm not claiming that it is, but I think it is a key difference, and you don't have to take my word for it. That's Professor Pertova's main argument, is that it actually does add an additional benefit to the data subject.
Wait, we had Nat Manning. All right, why don't you go first, since you have the microphone, and then we can. You paid for that microphone.
Exactly. Thank you. So it's only a short comment or a question. Then it's to have really a short-term possibility to get the people aware of what's actually ongoing. It's a question of educating the people, or it's not a question of technology or everything, because it's first of all educating the people that if they use Google Maps or whatever, they are the product. They are not the clients of Google, they are the product of Google.
Yes.
And therefore, for the first thing, afterwards we have to guarantee that we protect their data and have a transparency about what's going on. But first of all, at the short term, it's an educational point of view.
Yeah. Professor Schwartz makes a point that one of the main functions of his proposed U.S. Data Protection Agency is precisely that, to police terms of service so that you don't get that picture that Ms. O'Shea showed in Australia. There would be standard terms and plain English rules and all of that. It would be a very important part, because the whole problem you're trying to address is the information asymmetry, where data subjects have no idea what their data is worth or what somebody proposes to deal with it. And so yeah, that's a very key element. I agree.
Yeah. One comment, one question. You were saying that the value of that market is Facebook's market cap, although I'd venture that's probably much more, right? Because what we know is that the aggregation...
Isn't that enough?
Isn't that enough? But like the aggregation of data, it creates more value, right? And so if like Facebook only, it has more, but only has kind of what I've done on their platforms, which is obviously a lot. But if that were in my own system and I had that combined with my financial data and my medical data and my Google history, and I was willing to license that as a package out to somebody, arguably the pie could be much bigger if you brought the consumer into the equation.
Absolutely.
Is one theory, right?
Although, I mean, if you're bored, Google, just go into Google and Google the words Google AdTech taxonomy. And,
they watch everything, I guess.
Well, it's not that they watch everything. You as an advertiser can just go down the Chinese menu of like 190 different things and say, give me a paranoid schizophrenic person who likes pole dancing on the internet. And they'll be able to sell that guy some pharmaceutical product that's just right for that person. I mean,
But isn't it limited to Google's own data, though?
Well, yeah,
isn't that your point?
it's pretty much. But I mean, where I was sort of going on this is, in terms of engaging the consumer, saying, "Hey, can I have more? Can I have more?" These guys are already getting a lot, right? So, that one thing I just wanted to throw out there. I thought this is where you were going, is the concept of a derivative work. Like in copyright, there's like a mashup on YouTube where you take a song and you add it to a video. It's like, in the beginning, that starts as a copyright infringement, and after a couple of like changes in Photoshop and this and that, the other thing becomes an original work, and that actually has protection under the copyright law.
Absolutely. So it's one of the most important rights there is, actually.
And you were talking about life story rights. I mean, those are generally sort of left with sort of movie stars or there's a Seinfeld episode where Kramer rips off Jay Peterman's life, and he sets up his own. Or the other way around. I'm sorry.
Oh yeah, no. Life story rights are almost always ordinary people.
But
actually.
Is that right?
Yeah. Life story rights are almost always like the guy who saved a girl in a well, and so it's just they're not for celebrities.
Right,
Celebrities obviously they're licensing their performance more than their life stories.
I was curious. I mean, so building on, I was curious where kind of medical data rights. And right, so HIPAA and things like that, that's kind of our physical selves, and essentially
tissue.
where
Do you know the HeLa stem cells? Henrietta Lacks. Does everybody know who that is?
Oh yeah.
Yeah, she's basically responsible for some. May she rest in peace. For half of all the stem cells in the entire world. Absolutely no compensation to her estate. She signed I agree, right before she passed. Anyway, I didn't mean to interrupt you. You're
right. Yeah, I was just curious legally, if there's kind of where that ends. If your physical self is being created digitally all the time, and even arguably some of those things digitally are impacting or relevant to your health, do things like your, Apple Health Watch and Strava start to fall under, health details? And how far can you take that, actually? If Facebook is obviously affecting everyone's mental health, is there a legal argument there?
For the better.
Sure.
for the better.
Dopamine hits, right? They're good for you.
Actually, in some respects, the health thing would be a selling point, because I think everybody understands, like just leaving aside stem cells or whatever for a minute, but their MRI results, their whether they have lung cancer or whatever it might be, and the potential negative consequences to them of having the information get out. Right now, it's really subject to the same. I agree, sort of thing. But yeah, if it were a property right, my health records were a property right, and then I think you got an instant market in protecting that and monetizing maybe for the benefit to sell to pharmaceutical companies or whatever if you wanted to, but it would be yours and your property.
Just to maybe elaborate a bit on this. On the other hand, would also be, for instance, your localization data be practically worthless as an individual for Google Maps, whereas the aggregation of the whole localization data is what makes it worth something. So, as a property right,
yes and no, I think,
it'd be worth nothing as an individual, and you'd not be able to sell it for anything.
Well, I think that's an assumption on your part. I'm not an expert in any of this. This put over and over again, but no, I think a location data of an individual is considered valuable, right? So the nirvana for any retail store is to know that you, who have previously been online looking at used cars or new cars, are about to walk into an auto dealership. They absolutely want to know.
That's a global data. That's just not one. You cannot just sell your localization. You need to sell it along with your search history.
Oh, I see. Yeah, separately. Yeah, no, the market would sort that out, right? Yeah, absolutely. Nobody wants to know only one thing about you, and they know way more than one thing about you at the moment. So I was assuming that what we're talking about here is a property right in a collection of the same collection of data that people are monetizing now. Yeah, I agree. Yeah. Oh, you're standing in the way of lunch.
Just a little question. You said you're an intellectual property lawyer, and
yes, I'll cop to.
But you understand that the intellectual property, including copyrights and all that, is governed by an international agreement.
Berne agreement, absolutely.
There are many agreements. I think.
Yeah, many. That's the mother agreement. It's from the 1880s.
So what are the prospects of having the issue of privacy engulfed in an international instrument? What does it take?
What did it take in 78 to come up with the Berne agreement? To me, I think, and I was really intrigued by what Talal was suggesting about a standardization process. I think if you get no offense to anyone here, but an expanded version of this group in a room, and let's propose an international agreement, and then but mostly let's talk about what should be in it, and then build political support for it. That's exactly how all international agreements get signed. Paris Accords, Kyoto Accords, everything. It's all based ultimately on activists who want to achieve something, building consensus around what it is that people can agree upon, and then selling it to governments all over the world. And it has happened over and over again in places where there's no precedent. If you think about climate accords, it's nothing in anyone's constitution that requires a country to have a climate change policy. Nothing in any country on earth, and yet there are the Paris Accords, so it can be done.
I mean, by the way, I think the first step, though, is there needs to be an agreement that we need an individual right relating to this stuff. That hasn't been. I mean,
that would be the standardization group. And then to the issue of defining privacy. Let's get everyone, all the experts in a room, and let's hammer out a definition. That would be my.
The position of the CNIL. I mean, are you guys there? Do you believe there should be an individual right to data ownership, or like a property right, or no? Right. Right.
Read that book. She'll change your mind.
And it's definitely It's definitely not something we can answer just a national authority, and
I agree with that.
other European authorities are actually also reflecting on this, and we will take this to the EDPB, and of course we can. It's going to take a while to have an answer, but it's something we're exploring, and this is why we were.
Great.
We
So
were
I
here.
didn't mean to put you on the spot, but
No.
the point I'm making is that there isn't even a consensus on whether that's the right way to go. I mean, I approach it as an engineer. As an engineer, I try to find the sort of the minimal form and the lowest complexity solution to a problem. So I tend to view the Internet of Things and the Internet of People as having, you need an atom, you need like a sort of a space that you can have points in, and anything related to individuals should be rooted around the individual. That should be the origin of the system. And there's people, places, and things, right? You were talking about location, right? So if you look at the IoT and the big data environment, it's pretty much those three things take care of everything. And if you have people-centric data, the lowest complexity solution is to start with the person and their wishes and their intents, and then to start deriving digital rights around that with a thing, whether it's a light bulb or a thermostat or a car or something like that. That's performing certain functions owned by somebody, and you radiate out from there. It doesn't have privacy rights, but the people using that thing may have. So that's how those two things intersect. And then finally, sort of location is the last one. So I think that, and I'm also a licensing. I mean, I just spend a lot of time doing licensing, and that's been said several times today. Is you're no longer buying things. The days of going to a shop and walking out with a hammer or a suit, I mean, people still do that, but most of the time when we're transacting, we're actually licensing information. When you listen,
Buy a car, you're licensing the software that's in it.
exactly, or you listen to a song on Spotify, you're listening to it under license for certain things, but not other things. And I guess a lot of this conference is really about why don't we look at creating technologies and regulations and policies and standards that allow people to have a proactive role in the licensing environment, not just a one-way thing.